Hello, everyone. I'm Advocate Richard Crompton, and I'm a member of the NBCSA here in the Eastern Cape. And I'm also advisory board member to 4SA. Generally, the name is Freedom of Religion SA. And today I'm joined by Daniela Ellerbeck. She's the legal advisor for 4SA. And there's a new bill called the Anti-Money Laundering Bill. And we're here to discuss the religious freedom and religious organizations' implications for churches and other religious organizations. So the bill is currently open for comment until 12 o'clock this coming Monday. That's the 10th of October, 2022. So Daniela, what is the bill about?
So Richard, the Anti-Money Laundering and Combating Terrorism Financing Amendment Bill, which I'll simply refer to as the Anti-Money Laundering Bill, aims to change various laws, including the Non-Profit Organizations Act of 1997. And the aim is to ensure that non-profit organizations, NPOs, are not misused by terrorist organizations or vulnerable to terrorist financing abuse. Okay, so noble aim. Now, the changes in the bill follow recommendations contained in South Africa's Mutual Evaluation Report of the Financial Action Task Force, which require urgent legislative amendments. So that is quite a mouthful. So basically, the international community have said to South Africa, don't become a grey money country that can finance terrorism, make these changes to your laws. Again, noble endeavor. So we see that the bill has a good aim, but Richard, as always, the devil is in the details. After all, who would suspect that a bill about preventing money laundering or terrorist financing would affect religious freedom? But it does. So indeed, it's 4SA's view that the bill violates various constitutional rights, including but not limited to the right to religious freedom found in Section 15 of our Constitution's Bill of Rights, freedom of association found in Section 18, and the right of religious communities to practice their religion together and form religious associations protected by Section 31 of the Bill of Rights.
So just tell me a bit more about what your concerns are regarding this bill.
So Richard, the bill, amongst other things, proposes making registration as a non-profit organization, commonly referred to as an NPO, compulsory. Now, registration as an NPO with the Department of Social Development, or DSD, is currently something that is voluntary in terms of the Non-Profit Organizations Act of 1997. So the bill proposes changing the act to make it mandatory for all organizations that fall within the act's definition of what an NPO is to register with government under penalty of imprisonment or a limitless fine. So the NPO Act currently defines what an NPO is as any trust, company, or association of persons that is established for a public purpose and the income and property of which is not distributable to its members or office bearers except as reasonable compensation for services rendered. So one can therefore see how religious organizations such as churches would fall in the ambit of the NPO, of what an NPO is in terms of the Act, and would, if the bill were to become law, be compelled to register with the DSD or face criminal sanctions.
Now, isn't this a duplication of processes? Because there are other government institutions that religious institutions have to, or organizations have to account to.
Exactly. So the right of freedom of association gives people the right to associate with form organizations in whichever way they choose. And like we've said, specifically for religious associations, this is also then protected in Section 31 as well. So we see that religious associations have a double protection in the Bill of Rights. And in terms of current South African law, religious organizations typically organize themselves in one of three ways: voluntary association, a trust, or a non-profit company. Now, trust and non-profit companies already carry existing registration and administrative burdens. I would say quite heavy administrative and registration and financial burdens imposed by the Master's Office for Trust and the Companies and Intellectual Property Commission, commonly known as SIPC, for non-profit companies. So, for example, non-profit companies with SIPC have to be audited every year. They have to file annual reports. These annual reports have to be in a specific format that SIPC can read. So there's a lot of financial costs already involved, for example, for non-profit companies just to register with SIPC and be compliant every year. And the same is true for trusts. Now, in addition, voluntary associations, trusts, and non-profit companies also have to be SARS compliant because they also have to pay tax on all three of on all to SARS at all times. So all three entities have to be SARS compliant. So the NPO Act, in addition to this, has very specific requirements that religious organizations who want to register as NPOs need to do. So this includes submission of their founding documents, for example, a church's constitution, obviously the keeping of accounting records, regular submissions of financial statements, as well as narrative reports of the organization's activities and office bearers and so forth. Now, this will be in addition to the burdens already imposed on religious organizations by the other state entities. So you're right, a serious concern, therefore, is duplication, as religious organizations will now have 3 state entities to deal with: SARS, DIPSI or the Master's Office, depending on whether they're a trust or an NPO, and DSD. And they'll have to keep all 3 entities happy. And if they fail to keep DSD happy, Richard, this will result in criminal sanctions such as a limitless fine and or jail time, and obviously the closing of the church. So this will not only unduly burden religious organizations, who for the most part in South Africa, I have to say, is run on a shoestring budget with a small contingent of staff, but it's going to burden churches without offering any tangible benefit to them. In fact, quite the opposite will be true. All these administrative and financial burdens will sorely impact on religious organizations' ability to serve their communities effectively. And while we can understand, registration with SARS to keep the non-tax status, it's unclear what registration with the DSD will achieve other than to give government greater control over religious organizations, as we'll get to later on. And I also have to say that it's submitted that it's unlikely that the DSD has either the manpower or expertise to pick up, for example, fraud or money laundering, Richard, if SARS has failed to do so.
Yeah, I as you correctly say, these religious organizations do have to pay employment tax, but their submissions there are made for the purposes of maintaining the non-tax status to SARS, and of course SARS do consider their financial statements and other submissions, and every church has to do that. So it's very difficult to see what the DSD is going to add with regards to control, specifically when it comes to money laundering and terrorism and things like this. Now, do you think this bill opens the door for the state to interfere in a faith organization's doctrinal matters?
Richard, it does. So the NPO Act gives the DSD the power to require NPOs seeking registration to amend their constitutions. Now, religious organizations' constitutions are obviously crafted according to that religious organization's religious beliefs and doctrines. Thus, if this bill were to become law and every religious organization be required to register as an NPO, this bill will give the state broad and intrusive powers to prescribe to religious organizations, what their founding document requirements, for example, membership, who gets to be a member and when membership gets terminated, or leadership, who gets to be a leader and what the requirements are, what these need to be in their founding documents. And I mean, membership and leadership are just 2 examples of things that for religious organizations would be based on their understanding of holy texts, would be based on their beliefs and their doctrines. So if you suddenly have the state telling religious organizations no, change these things, that is state interference in an organization's autonomy and its meddling in its doctrine. So from a religious freedom point of view, if the bill is adopted in its current form, the state will have an open door to tell religious organizations how to run their internal affairs and therefore what and how to believe. And this is state regulation of religion, which will have the result of violating the right to religious freedom and freedom of association guaranteed by our Constitution. And I have to also point out that it will violate the long-standing doctrine in our law known as the doctrine of entanglement, which prevents the state from interfering with doctrinal matters.
Yeah, I was involved in a matter in that regard where the court point blank refused to get involved in the internal affairs of a church. And I think that that's a very healthy state of affairs, because the very essence of a religious organization is the ability to limit membership to those who actually believe what you believe. Now, what is 4SA's recommendations to the state? What are they going to say about this bill to the state?
Richard, one always wants to say to the state that they need to pick one route and stick with it. Does the DSD even have the manpower to register all religious organizations as NPOs? Like, let's just start with the basic. Do they have the manpower to register every single religious organization in South Africa? And after that, do they have the manpower to ensure compliance? And there are serious concerns that DSD will not have the manpower to assist religious organizations who, for the most part, will often not have the money to pay the lawyers to ensure that they are compliant with these new requirements. So, and as we've said, will DSD have the capacity to even register? And they definitely, in my opinion, won't have the capacity to reach out a helping hand to religious organizations who want to comply. But they're doing this at the same time while making it a criminal offense to fail to comply and imposing heavy criminal sanctions such as imprisonment. So obviously this will violate the various constitutional rights that we've mentioned. And these are all unintended consequences of the bill, but very serious consequences indeed. And what one wants to tell the state is that they need to pick one entity, be that SARS or the DSD or SIPSI, but they need to use that entity as a one-stop shop where, example, religious organizations can go, can get help with registering, can be educated on what the compliance requirements are, and only have to worry with complying with this one entity's set of requirements. The state needs to simplify and streamline the process, in essence. They can't come up with such a complex, convoluted process and then close churches and send pastors to jail for failing to comply.
Yeah, I'd agree. It's very difficult to understand what role the Department of Social Development has in preventing money laundering and terrorism. I would suggest that that's mostly a fiscal or monetary crime, and there are definitely better entities to deal with it. So the bill is currently open for comment until 12 noon on Monday. That's the 10th of October. What can religious leaders and organizations who are watching this interview do?
They can participate in the public comment process. So 4SA has drafted a template submission to assist them, and they can download this from the 4SA website, which is www.forsa.org.za. They are free to change this template submission as they seem fit. They are free to share it far and wide as they deem fit. But please, just send in a comment by 12 o'clock lunch on Monday, the 10th of October. The bill will then open for hearings the very next day on Tuesday, the 11th of October, which shows you the haste with which it's being put through. And 4SA has requested in our legal submission to Parliament on the bill that we be afforded the opportunity to make oral presentations on the religious freedom threats posed by the bill. And after the committee has finished dealing with the bill will go to the second House of Parliament, the National Council of Provinces, where hopefully it will again be open for public comment. So I just want to alert viewers to that this is the first round for public comment, but please already participate in it now. 4SA will keep a close eye on the process and keep our constituency and followers up to date.
I think this is an incredibly important issue, especially for smaller churches. And so there are a lot of small churches in the townships, in poorer areas who don't have the administrative wherewithal to do this, and it will impact them. And I would encourage every church to stand with your brother and send this submission in to oppose this bill, because it seems to be solving a problem that isn't the issue. The issue is terrorism and money laundering, and that should surely fall under the province of SARS. So we encourage you to send this bill out. Thank you, Daniela, for your information and helping us to understand these issues. And we really encourage everybody to get involved in standing for the church, standing for religious freedom, and protecting it in every way that we can. Thank you.
Good day. This is Daniela Ellerbeck, the legal advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.